Have you ever wondered whether an email sent by a company is legally valid under the Companies Act 2013? Can important notices, board reports, and shareholder communications be delivered electronically? What happens if a company sends documents to the wrong address? Today, we decode Section 20 of the Companies Act 2013 and understand the complete legal framework for service of documents. Welcome to Corporate and Securities Law Compass. Navigate law with clarity. Today we are discussing Section 20 of the Companies Act 2013 along with the applicable rules and practical corporate compliance aspects. Section 20 deals with service of documents. This section provides the legal mechanism through which documents, notices, reports, and other communications may be served by a company or on a company. The provision is extremely important because companies regularly send notices of meetings, annual reports, dividend communications, and regulatory documents. Improper service of documents can invalidate meetings, resolutions, and compliance actions. Section 20 recognizes both physical and electronic modes of communication. The law modernized corporate communication by permitting electronic transmission of documents. Under Section 20, a document may be served on a company or officer by sending it to the registered office of the company. The document may be delivered personally. It may also be sent through registered post. It may be sent by speed post. Courier service is also permitted. Electronic mode of delivery is also legally recognized. This provision supports digital governance and ease of doing business. The section further allows companies to serve documents on members through electronic means. However, such communication must comply with prescribed rules. The Company's Management and Administration Rules 2014 become important here. Rule 35 of the Company's Incorporation Rules and Rule 18 of the Company's Management and Administration Rules are relevant for electronic communication. A company may send notices through email to members, directors, auditors, and other entitled persons. The email address registered with the company or depository system is treated as valid. Listed companies generally rely upon email records maintained with depositories. Electronic communication reduces printing and dispatch costs. It also ensures faster delivery of important information. Section 20 further states that documents may be served by post under a certificate of posting. The law presumes delivery after normal transit period unless contrary is proved. This creates legal evidence regarding dispatch of communication. For example, if a company sends notice of annual general meeting through registered email to shareholders, the service is generally considered valid. Suppose a shareholder later claims that he did not physically receive the notice. If the company can prove dispatch through proper electronic records, the requirement of service may still be satisfied. The section also permits members to request delivery of documents through a particular mode. However, the member may have to bear additional expenses for special delivery methods. For example, a shareholder may request physical delivery of annual report through speed post outside India. The company can recover additional postal expenses from such shareholder. This provision balances shareholder rights and company expenses. Another important aspect is deemed delivery. If documents are properly addressed, prepaid, and dispatched, they are presumed to have been served. This principle becomes important during litigation and regulatory proceedings. Corporate secretarial teams must therefore maintain dispatch proof carefully. Email logs, courier receipts, postal acknowledgements, and tracking reports become important evidence. Improper maintenance of records may create compliance risk. Section 20 applies to many corporate communications. Notice of board meeting, notice of general meeting, postal ballot notice, financial statements, auditor's report, dividend communication, rights issue notices, share transfer communication investor notices. Secretarial departments must ensure correct and updated contact details of shareholders. Failure to update records can create practical disputes. For example, if a shareholder changes email address but does not inform the company, the old registered email may still be treated as valid for service. Companies should periodically request shareholders to update KYC details. Listed entities also follow SEBI circulars relating to electronic communication. During the COVID period, electronic dispatch became extremely significant. MCA issued circulars permitting virtual meetings and electronic service of notices. This increased dependence on Section 20 compliance. Another practical issue relates to bounced emails. If emails repeatedly fail, companies may need alternate methods of delivery. Good governance practices require maintaining evidence of attempted communication. Section 20 also protects companies against unnecessary technical objections. Minor procedural defects may not invalidate service if substantial compliance exists. However, intentional non-service or fraudulent suppression can create serious legal consequences. Courts generally examine whether reasonable opportunity and proper communication were provided. Now let us understand a practical example. ABC Limited sends AGM notice through email to all shareholders whose email addresses are registered with depositories. The company also publishes newspaper advertisement regarding electronic dispatch. One shareholder alleges non-receipt of notice. The company produces email dispatch report and depository data. In such case, service is likely to be treated as valid under Section 20. Now consider another example. A company sends notice to an old address despite receiving updated communication from shareholder. The shareholder misses the meeting and challenges the proceedings. Here the company may face legal difficulty because proper updated records were ignored. Section 20 therefore emphasizes both legal compliance and administrative discipline. The provision also supports environmental sustainability. Electronic communication reduces paper usage and printing expenses. Modern corporate governance increasingly depends on digital communication systems. Companies must therefore adopt secure communication infrastructure. Secretarial auditors also verify compliance relating to dispatch of notices and documents. Non-compliance may affect validity of meetings and resolutions. The board of directors should ensure proper internal systems for communication management. Companies should preserve communication records for future verification. Digital audit trails have become extremely important. Email server logs and delivery reports may become evidence before regulators or courts. Section 20 appears procedural but has major practical impact on corporate governance. Every company secretary, compliance officer, director, and corporate professional must understand this provision thoroughly. A simple mistake in service of documents can trigger disputes, litigation, and regulatory action. Therefore, companies should create robust communication policies. Before we conclude, let us quickly revise the key concepts. Section 20 governs service of documents under the Companies Act 2013. Documents may be served physically or electronically. Registered office remains central for service on company. Electronic communication is legally recognized. Proof of dispatch is extremely important. Members may request specific delivery modes. Proper maintenance of shareholder records is essential. Compliance with applicable rules and MCA circulars is necessary. Corporate communication is not merely administrative work. It is a legal responsibility with direct governance implications. Thank you for watching Corporate and Securities Law Compass. Navigate law with clarity. If you found this explanation useful, like, share, and subscribe for more detailed analysis of the Companies Act 2013, SEBI regulations, securities laws, and corporate governance provisions. Stay compliant, stay informed, and keep navigating law with clarity. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.